right, what are we doing on this?
I am not aware of any offers at this time. We would like to address the bond, and they have a 2-year-old child in common, so the parenting time exchanges as well.
Going to get it all into that. I'm trying to figure out what to do with this case today. Are we going to set it for exam, or what are we doing?
If there's no offer, yes, we would set it for an exam, Your Honor.
I just want to put on the record, we requested the 911 call yesterday, have not received it yet, so it's not in the file.
Okay. So the 911 call is the only thing outstanding?
I believe so.
Yeah. People, other witnesses available the 10th?
We'll do our best, Your Honor.
All right. Preliminary examination in person will be set June 10th, 2025, 9 a.m. before Judge Barr. As the bond.
And Your Honor, will that, I just want to be clear, it'll be Judge Barr, will that be on the Hogback location, or will it be at,
it's at the service center. All exams are at the service center.
Okay. Okay. And then as to bond, so my client is 39 years old. She's been a bus driver for 15 years at the Lincoln Consolidated Schools, no prior record. The parties have a 2-year-old child in common. And so, as my understanding, this is an isolated situation. Nothing like this has ever happened before. They do have, she's collecting child support from the complainant. And so we're requesting that she have a PR bond. We would want to see if they can have contact, I guess, via app close, and have the parenting time exchanges at the Ypsilanti police station on Michigan Avenue, where it's my understanding the complainant lives by that location, and that, as my understanding, that the stepdad could do. Mr. Maurice Davis has agreed to do the exchanges. The child right now is with the maternal grandparents.
Respond.
I would object to any change of bond. This case is extremely serious. It involves her stabbing the victim in the chest. He was found laying on the couch, bleeding profusely. He had lacerations to his hands, his forearms, his shoulder, a puncture wound to his chest. At the time she was arraigned, he was unconscious in the ICU. I have not heard anything from the victim regarding contact, and I would object to any change in the conditions of the bond and ask that it remain as said.
And Your Honor, if I could just briefly respond, my understanding is that there was a party, there was drinking involved, there were several people there, and that the complainant was not clear on who stabbed him. I don't know, I wasn't there, but my client has had nothing. She's never had anything like this before. It has been gainfully employed as a bus driver for Lincoln Consolidated Schools, which my understanding is that she would have that option to go back to school to support herself and her child. If she's incarcerated, she won't be able to do that. And the child is in the care of the maternal grandparents. And I don't, I think dad is paying like a small amount of support. So, yeah.
There were witnesses at this party who saw the defendant with the knife in her hands after the victim was stabbed.
Motion for bond reduction is denied. Bond will continue. Thank you.
Could we have a referral over for pretrial services for an evaluation on bond, or?
I don't care what you do. I just listened to the argument on bond. Her bond, and I don't know who you'd send it to. Ms. McCoy, if you want it sent to somebody, you figure out who it's going to be sent to. Her bond was set before the magistrate. The magistrate did their assessment of it. I've listened to your argument. Bond is denied. Bond will remain at $500,000 cash surety. Thank you.
All right. Thank you, Your Honor. Oh, wait, Your Honor, what about, so she's incarcerated, but the child is with the maternal grandparents. Can we have it where they just have the parenting time exchanges with the stepdad at the Ypsilanti police station for dad to be able to see his son?
I am not doing that.
Okay.
Thank you.
Thank you, Your Honor.
Your Honor, on behalf of Mr. Jerome Burns, Mr. Burns, would you state your name for the record, please?
Jerome Burns. Your motion.
Can we Sure. Hey, but Judge.
People have been approaching all day. Come on. Oh, we're already set. Okay, cool. I did. Yeah, I thought that was.
Thank you for that, Your Honor. Your Honor, obviously we're here today. The people filed a motion for a bond violation revocation.
Yes.
It was an emergency bond motion, Judge. I have had an opportunity to review the details of the motion as well as the supplemental report that was accompanying it with my client. My client would like to enter a plea to the violation of his bond in this matter. It would be a no contest plea. We are satisfied with the court using the information, the supplemental report as the basis for that.
You understand that, Mr. Burns?
Yes, sir.
You understand that I will accept the facts that are contained in here as true?
Yes.
All right. And you do not wish to have a full-blown hearing on this, sir?
Do you wish to have a hearing on this?
Is it what we just talked about?
A hearing is when we have testimony. Somebody comes out and says,
Yeah. And then,
do you not wish to have a hearing? Is that correct? If you don't have a hearing, that means you're pleading guilty to it.
well, Brandon. Yeah, yes, Your Honor.
Yes, sir.
I'm not going to do the hearing.
You do not want the hearing on this. All right.
Your Honor, if I may, before he enters his plea, we discussed at the bench and I informed counsel this morning, there's also an additional statement. We want to make sure that's part of the record.
Yes.
I missed it in the written motion that it is on the jail also provided. Defendant made a statement that if he is released from custody, that he would take the child that he shares in common with the victim away from her and leave, and the victim would never see that child again.
And Your Honor, I just, again, we're not disputing any of the information that's been provided, Your Honor. I think that it is important that we, for the sake of the record, clarify the intentions behind that particular statement. It was made. We're not disputing whether or not it was made. There is a difference in parenting. He does not, parenting styles, I would rather say. He has spoken to me previously about his views on parenting style and how they differ between he and his wife. He tells me that that particular statement was because he felt that the child would be better with him if that were to happen. If obviously they would have to go through family court and fight that matter out. He never intended on kidnapping or stealing or doing anything illegal as it pertains to his child. He has told me time and time again, he sheds many tears when it comes to his child and his child's health issues and what they have been through as a whole, as a family, dealing with his child's health issues, Judge. So that does not change our position today.
Can I just say, I'll let you go on, counsel, but I'm having a problem with that.
Okay.
Because I've listened to his phone conversations provided to the court in preparation for this hearing. I look at the words that he uses, and that sentiment does not by any means fit with anything that he has said at all.
I completely understand that, Judge. I know that when it comes to when we're given the opportunity to elocute on his behalf, Your Honor, there is some information he'd like for us to provide to the court. I don't know how helpful that is going to be, but I completely understand the court's position.
Your Honor, after that, I'd like a chance to respond.
Well, here's what I'm going to do. I'm going to refer to the bond violations regarding the contact, attempted interference in the case, comments regarding the court, also attempts to interfere with the orders of the court, and the statements being made and attempts to make direct or indirect contact with the victim in this case. How do you plead to those?
No contest.
No contest.
what I wasn't going to sentence him at this point in time. He is set for PCC next week in any event. So I was going to move any sentencing or anything that the court's going to do at that time, hear any statements that counsel wants to make, as well as any additional information from the people at that point, if that worked for everybody.
That's fine with us, Your Honor.
All right. That's 6-5, right? So the probable cause conference, which has already been set for 6/5/2025 at 9, continue to that day, and the sentencing on bond violations will be set at that time. All right.
Thank you very much.
At this time in the interim, however, what I am going to do is
Next week.
I am going to, given what the court has heard thus far, I am going to revoke the defendant's phone privileges at this time, however. Thank you. Bond will continue in all other aspects.
All right, you got
Versus Quincy Jones.
Hey, Pierre Rachel McDuffie for the people.
Cameron Dadish on behalf of Mr. Quincy Jones, who is approaching. Can you put it on the record?
Quincy Jones.
All right, he has a new case, you know that.
Yes, Your Honor.
All right. So, Mr. Jones, you have a new case currently, okay? And you're before the court on a complaint that alleges that on or about March 14, 2025, at the location of South Huron and Michigan Avenue in Ypsilanti City, that you did knowingly and intentionally possess less than 25 grams of a mixture containing cocaine. Do you understand that charge? I'm not saying whether or not you did it. I'm saying, do you understand what you're charged with?
Okay,
Do you?
I understand that.
All right. That is a felony punishable by up to 4 years incarceration, $25,000 fine plus court costs. You understand that? Mr. Jones, let me ask you something. If I had you tested right now, you gonna test clean?
For what?
Mr. Allen. Mr. Jones, what's gonna be in your system? Because I can't arraign you if you're under the influence of something.
I know
So you might as well just tell me.
some marijuana and
And what else?
probably a little bit of cocaine.
Probably a bit of cocaine. When did you take that?
Be truthful with you.
Huh?
Yeah, I'm be truthful with you.
Okay, so when did you take the cocaine?
About 2 or 3 days ago, so it ain't on my system yet.
Seriously?
Yeah.
So when's the last time you had any marijuana? You're on something,
Yesterday.
you're on something right now. What are you on? That you,
What do you mean, like?
the worst thing is to lie to me.
What do you mean? What do you mean, like, on something? Like, what do you mean? Like, did I do something to get today or?
I don't think that's really a hard question.
Oh, I smoked some marijuana last night.
Tell you what, it's real clear to me that you're on something. I'm not going to arraign you on new charges. I'm not going to do anything with these other charges. I'm adjourning all of this over to next week. But right now, on your one case, your bond's revoked, defendant's remanded.
Thank you, Your Honor. I.
Why? Good, that works. And I'm gonna set that for the, yeah.
Your Honor? Yeah, I gotta mark it up.
Good job to do.